Aloha, welcome to Jordan's Journal. I'm Representative Joe Jordan, and today I have my special guest, Representative Marcus Oshiro, and we're going to be discussing the upcoming special session, which will be held on October 28th, 2013, which is about 2 weeks from now.
Yes.
And some of the topics that'll be brought up, which would be the marriage equality bill.
Yes.
So I'd like to welcome you and thank you for joining me.
Well, thank you, Joe. It's good to be on Jordan's Journal. It's one of the more important programs out there on Olelo. It engages the community, and it's a very, very important issue.
Yeah.
What I have today is a series of PowerPoint slides that I'd like to share with you. Not all of them, of course, because there's too many of them, but I've been going out in my community, started off in Wahiawa, to answer a question from my constituents.
Mm-hmm.
What is a special session? Why is the governor calling a special session? Is it really necessary? Will people be allowed to participate? What about the bill itself? Does it protect the churches? Does it protect my religious freedoms and freedom of conscience? So those are the kinds of discussions I've been having in the community of Wahiawa, and having tremendous engagement with my constituents on both the process and on this important policy.
Yeah. I think me being new to the legislative process, I've been here a couple years now. I've never been in a special session. So even myself, I have all these lingering questions going on. What is a special session? Is it like a normal session? Is it not? Can we talk about more than just one thing during special session? How long might it be? Is public going to have process there? So maybe you can help me with that.
Well, let me tell you, first of all, a special session is a session in and of itself, is independent from the recently recessed session in May.
Okay.
And it's distinguished from the upcoming session in the third week of January. That's a regular session. This is a special session called by the governor pursuant to his constitutional powers to call us in, both the House and Senate. And he can kind of bring us in here, but again, he cannot dictate the result. He cannot prohibit us considering other issues, other bills, other measures. That's for the legislature to decide. So he can bring us in, he can propose a measure, but it's the legislature who will dispose of that measure.
Oh, okay. So he, in essence, called the special session.
Yes.
It wasn't like the House and the Senate saying, let's go together and have a special session. We were called into this.
That's correct. I think the overwhelming sentiment in the Senate was more than a majority of the members there wanting to come back in to a special session, or willing to come back in for a special session to address same-sex marriage.
Mm-hmm.
In the House, you didn't have that supermajority or 34 members. You had maybe a mere majority of members willing to come to a special session. That's not enough to meet the constitutional requirements.
Okay. So then, in essence, he makes an announcement.
Yes.
You know, and says, we're going to go into special session.
Yes.
And there's been a bill that they've been vetting out there, right?
Well, I wouldn't know if it's been vetted in the community or vetting with
okay.
a wider community membership, but it has been drafted by the administration, circulated amongst his attorney generals, deputy attorney generals, and some of the proponents of this same-sex marriage. And I think that's the measure that we're looking at right now. That's been on the governor's website for about, I don't know, maybe 4 weeks or so, as a potential draft to be considered.
Well, I found it very interesting because somebody walked into my office yesterday and said, hey, I hear there's this bill out there. How do I get it? Do I go to a certain rep or something? And I basically said it's on the governor's website. And you know, if it's been up there for almost 4 or 5 weeks and the general public doesn't know this, how?
Well, that's part of the problem with calling a special session like this on such an important issue. Whether you're for or against same-sex marriage, it is a very important issue. Most people don't have the wherewithal to get to a website and download it and print it out, and then much less understand the intricacies of the bill. Most people are not legally trained. Most people are not attorneys. And so to understand the bill itself and all the specialized language in there, what it means to lay folks, it's very difficult. It's a daunting task. So although it may have been out there for 4 or 5 weeks, I don't really think many people have actually accessed it, had a chance to download it, print it out, and really understand all the legalese and the technical language that's in the draft.
So I've only been here for like 3 years, and I know earlier this session there was a couple bills introduced for same-sex marriage, and those bills weren't heard during this past session. So in the past, maybe 8 or 10 years, has there been any bills introduced in the legislative process regarding marriage and a discussion had?
You know, I've been here for about 20 years. I first got elected in 1994, a very exciting time when Governor Cayetano actually became our governor. And it's during that time we had discussions on same-sex marriage. We had discussions on the Constitution. We had discussions on whether there's alternatives to same-sex marriage. And I believe in 1997 it was the collective decision of the legislature to approve a reciprocal beneficiaries bill, which gave a bundle of rights to those who could not get married, both same-sex couples, couples in intrafamilial relationships, a mother and a son, a father and a daughter. That was back in 1997.
Okay.
Called reciprocal beneficiaries. We also looked at a constitutional amendment to clarify the ruling in the Bear case and to make sure that the legislative branch has the authority to weigh in on this very important issue.
Okay.
Through the constitutional amendment, we were able to elicit the comments of our constituents, the voters of Hawaii, who in 1998, November 1998, I believe 70% to like 30%, said the legislature shall have the ability to define marriage as being between a man and a woman, and thereby activating the 1994 definition of marriage being between a man and a woman, and also setting aside the Bears' decision regarding their interpretation of the Constitution.
Okay. So then that laid on the table, and that's how this law has been read all this time.
Yes. In fact, it's interesting because it kind of went dormant at that time from 1998 forward. You need to understand that we're going through a recession during that time. There are other issues of the day, DHHL issues, Office of Hawaiian Affairs issues with collective bargaining, civil service reform, workers' compensation. There are a lot of issues of the day going on at the time. So during the Cayetano years, there were a lot of economic issues, dealing with education issues, but it kind of went dormant over those period of years. And then when he left office, we got a new governor, Linda Lingle came in. This is in 2002. And during her tenure, it went silent. There was really no discussion of same-sex marriage during her tenure. She didn't support same-sex marriage. Only, fits and starts of some discussion, but there was really a strong opposition from the fifth floor that many of us did not feel very encouraged to even have that discussion. Okay. So it was really silent.
It was silent on marriage. Okay.
Yeah.
So then the alternative was?
The alternative at that time was to look at some other options what other states are looking at. At that time, there were, I think, the 3 or 4 states that are looking at civil unions or reciprocal beneficiaries or some kind of other bundle of package of benefits for those who could not get married. Okay. And that's when we started talking about civil unions, I think in the mid 2000s. I think Sylvia Luke was the judiciary chair. I mean, Eric Hamakawa, Sylvia Luke, John Riki Kawamatsu. We had those discussions with these options.
Okay, so then you're talking about the mid 2000s.
Yes.
And then that finally got over the hurdle and passed.
In 2010, when Governor Lingle was still there, of course she vetoed it and we did not come back. And then that was the election year.
Yeah.
And then we elected Governor Abercrombie in November.
Oh, yeah, okay.
And so the first enactment that he took great pride in was Act 1 in 2011, I think in February of 2011. Act 1 approving civil unions for the citizens of Hawaii.
Yeah. But that was like almost a 7 or 8 year discussion in the body.
It was a long discussion, and I think even at that time we weren't really that focused upon the other compelling interests at stake in this same-sex marriage of our religious freedoms or our Bill of Rights or our First Amendment. Yeah. Both a prohibition against state instituted religion, but also the freedom of religion, or, freedom of speech, freedom of press, freedom of assembly, petition. Those very important rights and privileges of citizenship under the First Amendment against due process, equal protection. We really didn't have that discussion.
Oh, okay. So then he signed in 2011.
Yes.
Civil unions, and that would be in effect start January 2012, right?
January 1, 2012, that's correct.
So then civil unions, my understanding, is all the equivalents of marriage benefits for the people in Hawaii that have a civil union, correct?
Yes.
And that would mean we could file jointly with the state of Hawaii.
Yes.
You know, I would basically, if something happens to you, we have our tenants by entirety for
Yes.
property rights, and
Right.
if you pass away, then I can still stay in the property. I mean, that pretty much what an average, you know, male-female marriage, they had the equivalents in a civil union.
That's correct.
Correct? So we had given them half the apple, kind of, right?
Well, I think all the benefits, and I say burdens too, of being
Oh
married.
yeah, there's burdens.
Yeah. Except the use of the term, marriage,
Yeah.
and that constitutes certain benefits or privileges in and out of the country, in and out of the state.
Yeah.
We did not give them that.
Yeah. So, you know, doing my research for this up and coming session, you know, I went and looked and said, hey, well, my understanding is when we passed civil unions, if you were married in one of those, at that time, 12 other states that had same-sex marriage or marriage equality, the term you want to use, so California or New York or Massachusetts, then if you are now living in Hawaii, then you can easily just go to Department of Health, check off the box, and you can have your civil union in Hawaii, correct?
Yes.
Yeah. So, you know, so they would get those benefits in Hawaii. But
Yes.
because we said civil unions were not marriage, the federal government did not recognize civil unions or reciprocal beneficiaries or common law, as some people like to use, or, you know, whatever terms they want to use. The federal government doesn't recognize those other than that marriage definition,
That's
right?
correct. That's correct.
So, you know, we're moving along and we're doing pretty good, right? You know? And then all of a sudden, you know, there's this case.
Yeah,
Right?
we refer to it as the Jackson case. It's I think two same-sex couples brought suit alleging that the Hawaii marriage laws limiting marriage to two heterosexuals or two opposite-sex couples is a violation of the federal Constitution.
Oh.
The federal Constitution, equal protection or due process provisions. So the status of it right now, as we speak, it's gone to the district court. I believe the district court judge here, Judge Kay, sustained Hawaii's marriage law, that there is a rational basis to have this distinction in Hawaii's law. And it's now on appeal at the Ninth Circuit Court of Appeals in San Francisco. So it's kind of taking the same course as the Perry versus Schwarzenegger case or Perry Hollingsworth case, going to the district federal court, the appellate court, and then maybe one day actually appear before the United States Supreme Court. But as long as there's no final ruling, the law of the land is that Hawaii's marriage laws are still constitutional. Hawaii's civil union law is still constitutional. There is no deprivation of anyone's equal protection or civil right under the current laws.
Under our current laws, Hawaii's current laws.
Hawaii's current law.
Okay. So then, you know, they had this big case earlier this year, the Windsor case out of New York, right?
Yes, yes.
And I guess the Supreme Court ruled this past June saying that they were denied some sort of benefit when the spouse, because they were a married couple in New York, long time couple, like 45 years or something, and when her spouse died, she had to pay a federal tax.
Oh, yes, substantial.
You know, inheritance tax.
Substantial amount of money,
because they couldn't file jointly.
Right. That's
so
correct.
I think that got picked up by the federal courts, and they ruled on it, and they deemed that was not fair.
Yes.
And then they pulled down part of Section 3 under the DOMA Act, right?
The Defense of Marriage Act.
Defense of Marriage Act, correct? So at that point in time, then I guess the federal government starts stepping back a little bit and looking at their rules and all their different regulations, you know, with the Internal Revenue Service and maybe some of the branches of service and needs, right? You know, and as these things started rolling out, now they say, well, if you were married in New York or Massachusetts or California prior to that, then now you should be able to file jointly.
Yes.
You should be able to go back several years and file jointly with your significant other, your spouse, and hopefully reap benefits of returns or whatever it is, right? So how would that affect Hawaii? Because there's this urge to, we're denying somebody's benefit.
Well, I think first of all, I think much has been said about the Defense of Marriage Act, DOMA, the Windsor case, but I think in a nutshell, it stands for the proposition that where and how a state defines marriage, whether it's heterosexual marriage or same-sex marriage, Congress does not have the ability or authority to restrict that to only heterosexual or opposite-sex marriage, and that the law of the land will be to recognize and defer to the state's definition of marriage. So in this instance, because New York State recognized the couple who are, I think, together for 40 plus years, married in Canada actually, but recognized that marriage as valid in New York, the federal government would do so. And if you understand that rationale, it seems to make sense as far as ceding to the states the full authority that they normally have to define marriage. On the other side, I think the proponents were a little bit disturbed with the ruling, because that means that the other 33 or 34 states that have chosen not to define marriages between same-sex couples, again, so that's also going to be deferring to the states.
So then, we got these other states that might not have marriage.
Right.
So then,
which includes Hawaii right now.
Yeah, which includes Hawaii, because Hawaii defines it between a man and woman, right? But we have civil unions.
Yes.
So our constituents come in and they talk to us about this. They vet it, and I know I've met several people that were married in California, or New York, or even Canada. So those individuals now, technically, when this Supreme Court ruling came down, and then the federal government started putting out some, points on this, how informational points. So technically, it doesn't matter if you were married in New York or California, and you might live in a state now such as Florida or Texas or even Hawaii.
Right.
You still don't lose your federal benefits, right?
Yeah, that's right. I think they're applying what they call rule of celebration. Is where did you get married and in what state you got married. If the state recognizes same-sex marriage, so too will the federal government. Not where you're currently domiciled or currently a resident, but where you got married. And so people here right now, and this might not be the perfect solution, might not be the best solution, but if they really want to get married and have the federal benefits now, can go to California, can go to Washington, can go to the East Coast, New York, Massachusetts, and get married, and then come back to Hawaii and resume their lives. And because of the Windsor decision, we'll have all the federal benefits and privileges made available to them.
And and if they didn't have a civil union at that time, they can go to get their civil union in Hawaii, and then they'll have their Hawaii benefits to file with their spouses, and in essence, they have all the privileges and rights.
And that's, I think, is a more immediate type of action that they can do individually, versus us going into a special session, making wholesale change to the law without being properly vetted on all the other consequences and attendant effects upon not only marriage laws, but property laws, transactional laws, education, the curriculum of schools, you name it. There's a lot of effects, and of course, the First Amendment, our religious freedoms. Of not having a state-instituted religion or support for a particular religion or sect or denomination, and also the freedom to express our views and to have and our own faith and convictions, and really the conscience, the ability in the First Amendment to have a freedom of conscience, to believe and not to believe. So we're not only talking about religion in the formal sense, but your belief system.
So I'm still trying to get over these hurdles by saying, well, if we vetted, a civil union measure for 6, 8, 9 years, and there's been these words out there where we've been talking about marriage long enough, it's time for us to move forward. And I don't see that discussion happening in maybe this forum, meaning the legislative forum, where people can come and argument, points on a bill or measure.
Well, let me share with you a slide that I've used when I go out there and I say, well, these are some facts that I've extracted from the public record when we go back and look at who was actually here in the House during those years when we had vigorous discussions in the public forum on same-sex marriage or constitutional amendment or reciprocal beneficiaries, these are the 10 individuals, and it includes myself. So Representative Kachola, Ito, McDermott, Oshiro, Saiki Se, Suki, Takai, Takumi, Thielen, and Ward. We were there going through these long, vigorous, heated debates and discussion. So really, a majority of the members here have not had, like yourself, had not had the opportunity. Also, no state legislature has approved same-sex marriage only in 5 days. I can even go to say probably no country, even the European countries have done it in merely 5 days. And so I also share with the constituents that I have concerns about the process because this bill that's based upon a Senate bill was not discussed last year. No, the year before. No, the year before. And then most members were not in office at the time. And committee chairs, by design and nature of a special session to get in and out as soon as possible, will have to limit testimony. 1 minute, stand in your testimony. We got your written testimony. Thank you very much. They'll set the time and date of the hearing. And most votes will occur when people are not working. So those are some of the concerns that I raised when you talk about a special session on such an important issue that has not been thoroughly debated in the larger community.
Yeah, and I think that's some of the concerns I have. Even during a regular session, we might vet on these measures for 2 months, 3 months. During the different committee processes, and I'm still having a challenge of getting over the hurdles of, okay, if we focus just on one measure in 5 days, I don't see how we can educate the 80% of the remaining of the body that wasn't in these discussions in the last 12, 13 years, as well as to allow fully vetted public participation in the process.
Yeah, I share the same sentiments. I've been going out there and trying to explain to people that it is my hope that the governor would reconsider his decision. But of course, it's his prerogative, his choice. Okay, but let's say that's true. We go into a special session October 28th, Monday. There's nothing to compel us to not consider other options or other bills.
Oh, okay, so it's not just one.
Not just one.
Oh, okay, so it kind of opens it up for...
Oh, yeah, that's the thing about going to a special session, and I've shared with people, this is the first time that I've been here in 20 years that a governor has unilaterally evoked his power as the chief executive under the Constitution to call the legislature in unilaterally.
That's a huge statement. Yeah. Wow.
No. This is a big deal because post 9/11 there was an agreement between Governor Cayetano, I think Norman Mizuguchi, President Mizuguchi, Calvin Sid. We all agreed to come back in. Similarly with Governor Lingo, as a Republican now, working with a Democrat House, Democrat Senate, we agreed to come in to address a Hawaii Supreme Court ruling that would have shut down the super ferry.
Oh yeah.
So Senate President Hanabusa, Senate House Speaker Calvin Sid, and Governor Linda Lingo came together to formulate a plan and work together collaboratively. But in this instance, you did not get the assent of Senate President Donna Kim on behalf of the Senate. You did not get the assent of House Speaker Joe Suki. So it's very unique, very different than in past special sessions when you're going to be making new law.
Yeah, this is brand new law.
This is brand new law. You got to understand that this area of same-sex marriage in the United States itself is a relatively new area of law. I think when I review the legislatures who have passed same-sex marriage, the law is only about maybe 3 years old at the most.
Oh wow.
If I look at where the court has made a ruling through its interpretation of the constitutions or law, maybe about 4 years.
Oh.
But it's really a slowly developing area of law, of practice, of tradition, that I think behooves us to take a more prudent stance and study what's been going on out there. Study what's the best practices. Study what's the best approach to make sure that we don't abridge other people's freedoms of conscience.
Yeah. Well, I don't think we can get that done in 5 days.
Well, only if you're as astute and sharp as you, Joe.
And I think I think a lot of people don't understand that. you know, and maybe some people might feel pressure. I'm not quite sure how to explain it, but you know, even with constituents out there, they don't understand, you know, how does the process work? Is it the same as a regular session or not? You know, am I going to be able to participate or not participate? Are you guys going to pass something and not have us even say anything?
Well, truth be told is that the special session is geared to get in and get out as soon as possible. It's the most efficient way of making laws. But at the cost of public involvement, public participation, public reflection, that's not going to occur. We can go from 5 days up to 45 days.
Oh, okay.
We can do that, and that's on the prerogative of the respective chambers, Senate President, House Speaker to work that out. So there can be a timeout, consider it. But the way it seems to be going right now on the traditional mode to get in and get out as soon as possible means that it's going to be in and out, little amendments, if any, little reflection of one's testimony, no matter how compelling, because they want to get something out. And that's the greatest fear I have, because not knowing the outcome of the effects and how it affects all these other laws and policies we have in place, it's really opening up Pandora's box. And so for many of my colleagues, what I'm sharing with them is this: if you don't know, take a precautionary approach. Use the precautionary concept of doing no harm. And so let the status quo remain for that period of time.
Well, we're going to run out of time, and we could probably talk about this for the next 4 hours. I really want to thank you. You are having some meetings, you know, around town, or when you're asked to come out, correct?
Yeah, I go upon, you know, I'm a state representative, so when people want to invite me over to talk about the process itself, I'm happy to share my experience with them. Okay,
so you would be open if somebody was to call your office, then you can have maybe a presentation.
Yeah, all I ask is at least 2 or more people there, and maybe a slice of apple pie.
Okay. Well, I really want to thank you, Rep. Oshiro. I truly appreciate it, you know, and all the help and guidance that you're giving me as a new member of this body. So thank you for joining me, and I'd like to say aloha. We'll see you on our next Jordan's Journal.